Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television, from the Helping Seniors Network of information, education, and resources.
Helping Seniors TV invites you to sit in on your legal documents checklist with elder law attorney Tyler Runte of the Law Office of Amy B. Van Fossen.
My name is Tyler Runte, and I work at the Law Office of Amy B. Van Fossen. A little bit about myself. So I was born and raised in Ocala, Florida. I went to undergrad at University of Florida and law school in Jacksonville. When I graduated law school, I went back to Ocala and worked as a public defender in Marion County. And then my husband and I moved here about 2011, and we have 2 little kids now, 3 and 5. They keep me very, very busy and very tired most of the time. But I started at the Law Office of Amy B. Van Fossen probably about 7 years ago, and I find that this is where I belong. It is a wonderful field of law. Areas of practice, so I do love this field of law for this reason. These are our areas of practice. We do elder law. So elder law encompasses Medicaid planning, VA planning, estate planning, probate, case management, litigation, guardianship, and trust funding. So trust funding is just kind of a subset of estate planning. But these are areas of practice. And we'll get into the estate planning for the most part today, because that's really getting your ducks in a row in the estate planning world. So what documents do you need to make sure your ducks are in a row in the legal realm? And I will say that of all of these areas, I do primarily practice estate planning, so that is where I live every single day. So what is the difference between estate planning and elder law? So that's kind of a common question we get. What is elder law? So I'll start with elder law. Elder law is a specialized area of legal practice that includes all of those things that were on the previous slide: estate planning, probate, really aging plans, so getting your ducks in a row as you age. Can deal with elder abuse, VA and Medicaid benefits. So elder law is really the big umbrella, and then estate planning is a specialized area, which estate planning is the act of preparing for the transfer of a person's wealth or assets when they pass away. Those assets could include life insurance, pensions, bank accounts, think savings accounts, checking accounts, homes, rental properties, cars, anything you have when you pass away. That is getting prepared so that passes how you want it to pass. So when we talk about getting our ducks in a row as far as estate planning goes, what documents do you need? What exactly, you hear all these words, durable power of attorney, living will healthcare surrogate, wills, trust. What do you specifically need? And if you were to come into our office and say, I have nothing in place, I've never had any of these documents, or we've moved from another state, or my document's older, if you have these listed right here, you are going to have your ducks in a row. Now, are they all needed? Possibly. That's why you consult with an attorney and find out what you need. Do you need all of them? Do you need some of them? If you already have had some prepared, you might not need all of them. But if you have these listed here, you are in a good position. So that includes a revocable trust, a will, a living will healthcare surrogate, a PreNeed Guardian, a power of attorney, and a deed. So if you have real property, a home, a residence, you want to make sure that your property is titled correctly. So what happens if you don't have all of those documents? You might find yourself in probate, which probate is something that lots of people want to avoid. It's expensive, it takes a lot of time to get through the probate process, so most people want to avoid probate. We certainly can help you do that. If you don't have those documents that were listed on the previous page, you might find yourself in probate. The definition of probate is the court-supervised distribution of a person's assets after he or she passes away. So probate happens if you do not have your assets titled in a certain way so that they transfer without probate when you pass away. If you have to go to probate, the court gets involved and a judge appoints a personal representative for your estate and then signs orders that distribute your assets. It takes a lot of time, especially since COVID. We've found and seen that the resources are just lower. There's not as many people involved in the process on the court side, so it takes a lot of time, and it's also very expensive. So people want to avoid this if possible. If you've had a loved one that has passed away and you found yourself in this process, you probably understand that. It's something that you want to avoid, if possible. So again, it's time consuming and frustrating, and it also is kind of a public process. So a lot of the documents are put in the public record, so anybody that wants to view them can. And there's ways to avoid that, to not have it be part of the public record, which we'll talk about in just a second. We've said in the past that most probates last about 12 months. Some can go on for a lot longer, and that's what's happening now. 12 months is kind of on the shorter side now in most cases because of the lack of resources. It's taking longer. Courts are backed up. They just have a backlog. So, again, want to avoid this if possible, and we can help you do that with having all of the appropriate estate planning documents in place. So one of the easiest ways to avoid probate is to have a revocable living trust. A trust is a vehicle where you create the trust. You are the grantor of the trust, the creator of it. You nominate a trustee. Usually the trustee is yourself while you're living, and you have beneficiaries of the trust. So where you want your assets to go when you pass away. Your beneficiaries might be a charity, or they might be a family member, friends. Your beneficiaries can look however you want it to look. Some people do percentages, some people do specific amounts of money to people, but your beneficiaries can be very specific. With a revocable living trust, of course, it is a way to avoid probate. It can have some tax implications. But this one is what I was talking about just a second ago, that it assures maximum privacy over probate or any documents filled with the probate court becoming public knowledge. So a trust is a private document. No one sees that. No, it doesn't get recorded. It doesn't get put in the public record. So all of that information is private, which of course most people want their beneficiary designations to be private. It's not something that you talk to everyone about. That's a private matter. Also, there's rapid distribution of assets to beneficiaries after you pass away. So I was saying you nominate a trustee, usually you during your life. After you pass away, you have successor trustees. So who is going to manage your trust when you are gone? That is called your successor trustee. We have corporate trustees in the world, so you might nominate a bank or a law office, but as well, it could be a family member, it could be a friend, it could be anyone that you want it to be to manage your trust and distribute your trust assets when you pass away. You also, in your trust, I think a really important point about having a trust is that it can be tailored to exactly how you want it to be. So some people have sub-trusts in their trust, and not to get too complex or complicated, but let's say you wanted a beneficiary to only receive money if they went to college or passed a drug test or certain criteria had to be met. That can absolutely be written in your document. So the point I want to get across is that these can be tailored specific to you. Whatever your wishes are, that can be drafted in the document. So questions to answer when you're thinking about creating a trust is, who would be your successor trustees? So a lot of people do choose their children, but it doesn't have to be that. Like I was talking, you can have a corporate trustee, but you want someone that's financially responsible and someone that can handle the job. Also, who would be your beneficiaries? So who is going to inherit from you? And like I was saying a minute ago, that can look any way you want it to look. It could be lots of people, lots of charities. Some people list, one child, but however that is to look for you, we can certainly do that. And I want to also speak to the thought that I think it's a misconception out there that I need to have a lot of money to have a trust. I think that was a thought years ago, but that is not the case at all. Trusts are valuable tools for anyone. If you have one bank account or one piece of property, it could be worth $5,000 or $1,000. You still could benefit from having a trust. So it's a valuable tool for anyone. And it doesn't have to be overwhelming as well. I think that when you hear the word trust, it kind of gives some people some jitters, like, oh, I don't know. I've heard of that, but I don't think I need that. That's not for me. But that's certainly not the case. It's valuable for anyone. In our office, we try to make it as comfortable of a process in creating not just a trust, but all of our estate planning documents. We try to be, kind of bring it down to the level that we try to actually make it fun, believe it or not. So we try to make it fun and comfortable and as simple as it can be. So the next slide goes into wills. So if you have a trust, you would have a pour-over will that goes with your trust. If you do not create a trust, you still are going to want a will. Everybody, at least at the very minimum, needs a will. That is the document that says who is going to inherit from you, again, like a trust. So if you have a trust and a pour-over will, they're going to read almost identical. You're going to have the same beneficiaries, the same personal representatives is what they're called in a will, but they're similar to a trustee. It's the same person that wears a different hat. So a will is used during the probate process. So let's say you end up finding yourself in probate. You are going to use the will during that process. I think another misconception is that, oh, I have a will, I don't need to go to probate. That's not the case at all. A will is used during the probate process to direct the judge as to who you want your beneficiaries to be, as well as who you want your personal representative to be. The judge will be the one that makes the final say or orders such, but you say in your will who you want those people to be. So if you have a simple will, you would need to, or a pour-over will, you're thinking about who would be your executor or your personal representative. Those two words are interchangeable, mean the same thing. So who is going to be in charge of you distributing your assets when you pass away? And then who is going to be your beneficiaries? And who will be your beneficiaries? And similar to with the trust, that can look any way you want it to look. Okay, now kind of changing from the trust and the will, those documents being used when you pass away. So your trust and your will are used to say, who's going to administer my estate or my trust assets, and who's going to benefit from it? Who are my beneficiaries? So something different is the living will healthcare surrogate. So this document is used while you are living. If you were to come into our office and let us know you do not have this document, you would receive it's a combination. So it's one document that includes both of these items, your living will and your healthcare surrogate. Your living will identifies your healthcare wishes, your living will healthcare surrogate, I should say, identifies your healthcare wishes in writing. It informs your family and doctors of your wishes if you become unable to make decisions for yourself. So the living will is the document that says, I do or I do not want to be kept alive artificially. So if a certain set of criteria are present, do you want machines to be turned off, or do you want them to be left on for an indefinite period of time? Is someone else going to make that decision for you, or are you wanting your loved ones to know your wishes while you're alive? So that's the living will. That's, it's not the funnest topic to talk about, but it is so important that family members know what you want. We always tell people, losing a loved one is hard in itself. You don't want to put on your loved one that survives you, the pressure or the thought, did I make the decision they would have wanted? So it's so important to have this document in place. It's just something that makes it more comfortable for everyone. The healthcare surrogate piece of the document states who you want to make medical decisions or healthcare decisions for you while you're living. So let's say, and this could be useful for anyone of any age, anyone over the age of 18. So if you are in a car accident and you need surgery or you're in a coma, who would tell the doctors, yes, I consent to that surgery, or please give them this medication. So the healthcare surrogate piece is absolutely beneficial for anyone at any age. And it just says who is to be the one to tell doctors yes or no, or give them this or don't give them this. And again, it's if you are able to communicate your wishes on your own. So of course, you continue to make decisions for yourself while you can, and then it's that time if you were to become incapacitated, even for a brief period of time. So it could be, they're in surgery under anesthesia, and someone else needs to make a decision as to what the next step is. Well, as soon as you come out of that and you're able to make decisions for yourself, the healthcare surrogate would take a back seat, and you continue making decisions for yourself. So this slide gets its own because it is so important that you talk this over with your family. What are your highest priorities? Is it to be pain-free, to not be placed on a breathing machine, to have everything done to keep you alive as long as possible? And this issue is such a personal preference. I mean, there's people on both ends of the spectrum, and neither is right or wrong. It's just a personal preference. So you just want to make sure that your wishes are conveyed. And I think with the living will, it's important to know the difference between a living will and a DNR. So a lot of times we'll have people that come in the office and they say, oh, I have a DNR, I'm good, I don't need a living will. And that's not the case. A DNR is a do not resuscitate order, which is a bright yellow sheet of paper that should be placed on your refrigerator, in your wallet, somewhere that if paramedics were to come, let's say to your home or to a car accident or find you, they would know, okay, I see this bright yellow piece of paper, they do not want to be resuscitated. A living will is different in that I usually think of a DNR as they had a stroke or a heart attack or something like that. A living will can be a slow, steady decline in your health that at some point gets to, maybe a vegetative state where the machines would be turned off. So they are two different things, and you may want both or you may want neither, but it's important to know that they're two separate documents. Biggest takeaway is talk to your family, make sure everyone's on the same page, and everyone is comfortable with your wishes and knows what your wishes are. Not that they have to agree, but they need to know what you want. So for the healthcare surrogate, you will list someone to make medical decisions for you, and then you'll want to put a backup. And that goes for all of your documents. Same thing with a trust and a will as far as your personal representative or trustee. You always want a backup plan to your first agent. So you have one person listed, or maybe two, and then you want a backup plan. If that person predeceased you, or if that person was unable to make decisions for you, who would be the backup? And then as far as the living will, do you want one? Do you want life support terminated? If so, at what stages, under what conditions? The next document is a PreNeed Guardian form. So a PreNeed Guardian is a declaration naming a PreNeed Guardian and used to designate in advance the person you want to manage your affairs and act as your guardian should you become mentally or physically disabled or incapacitated. So this often happens as people age, think Alzheimer's, dementia. This is when a doctor says this person can no longer make decisions for themselves. They lack capacity. So a doctor will provide a report or an evaluation that says this person cannot make decisions for themselves, and a case is put forth with the court, and a judge will determine who should be this person's guardian. If you have this document in place, you, before becoming incapacitated, have said who you want your guardian to be. If you do not have this in place, the judge would decide, or the panel of people over your case. So in our community, and in every community, there are professional guardianship services that provide this service. So let's say a person doesn't have a family member or a friend in town that is capable or wants to be their guardian, you may find yourself under a guardianship, professional guardianship. If you have the PreNeed Guardian, you say who you want your guardian to be if that situation ever arose. So for a PreNeed Guardian, who do you want to be your guardian, and who do you want to be the backup? Oftentimes this is children, but oftentimes you might not have children in town, or you might not, that might not be the right fit, or you don't have children. Our office does case management, so sometimes we act as fiduciaries in capacities that I'm talking about. But there are lots of companies and organizations that provide that type of service, so that's always an option too. I think that it's scary for some people that don't have loved ones in town or loved ones at all. They don't have any friends or family. There are companies out there that are designed to do this for people. All right, the next one is a power of attorney. So this is a big one, arguably to us the most important. So a power of attorney is a legal document that allows someone to make broad legal and financial decisions for you. So think, if I'm unable to make legal or financial decisions for myself, who's going to do it for me? Which gives people the scaries sometimes, because it's money and it's someone else handling your money. So you want to make sure you're naming your most trusted person, or your confidant, to act in this capacity. Some people have the medical nurse, emotional child, and the more financially, so that works out for those people. But you want to make sure that you have someone that can handle this job and won't act, is frugal enough or financially responsible enough to do this. Because it's important that your money is used wisely as you age. Should you need to go to a nursing home or an assisted living, all those things are really important. So Florida has in October of 2011 and in 2013, Florida's power of attorney changed drastically. So if someone comes into our office that has a power of attorney that predates these times, we recommend that it's redone, absolutely. Florida now has specific powers listed within the power of attorney document that must be initialed to allow your agent to do those specific things for you. All of those specific items are very, very, very important. Should you need to qualify for Medicaid, should you need some other sort of benefit, you need to make sure those items are initialed. A lot of people think, oh, I had a power of attorney done 20, 30 years ago. It needs to be redone. Absolutely needs to be redone. So a power of attorney is good while you're living. Once you pass away, the power of attorney is no longer valid, and then it kind of transfers over to that trust or will document that takes over and someone acts for you after you've passed. So this is good while you're living. Another little note is that our office typically does general powers of attorney or durable powers of attorney, but there are specific powers of attorney out there that can be done, or special powers of attorney, they're sometimes called, for just one specific purpose. So if you want to allow someone to act for you in a real estate transaction, that can be done. So questions to ask when you are thinking about having a power of attorney. Who do you want to make these decisions for you, and are they financially responsible? Who is the backup to that person? Are they married? Do you like their spouse? And the reason why we put that on there is the spouse isn't the one making the decision for you, but your agent can certainly consult anyone they want to. No one's looking over their shoulder saying, well, don't talk to this person about it, or you can't have this conversation. So you want to make sure that it's just a right person in the whole scheme. Do they have capacity to make decisions for you? Are they on the verge? Is it someone that you're not sure today or tomorrow might be the right person? You just want to think it through. And again, there are offices, law offices that can act in this capacity, or banks or such that can do this for you if you don't have someone for yourself, or case managers as well. Another important point on here is you don't want to wait till it's too late. So you can only sign documents while you have capacity. We find that a lot of people, even right before losing capacity, sometimes they get a little bit guarded. So if you have family members that you see trending that way, it's important to get these documents done soon so that you don't wait till it's too late. If people aren't able to sign the documents, then you might find yourself in guardianship, which, you try to avoid that, of course. So some of the benefits of planning ahead. Of course, we always say be proactive, be prepared, have these conversations, but it can avoid lengthy and expensive probate or guardianship processes, allows control of how your assets are distributed when you pass away, gives family members access to medical records while you're living. That, of course, is the healthcare surrogate one. You're allowing someone else to have healthcare information about yourself. Allows someone to make legal decisions for you if you're not able. That's the power of attorney. So you're allowing someone else to make decisions for you legally or financially. A step further from just the estate planning documents is planning your aging plan or your family plan. So having a conversation with your loved ones about a broader scope than just estate planning documents. For instance, what's going to happen if you can't stay home anymore? Are you going to go to an assisted living? Are you going to have in-home care come in? Are you able to afford that? Do your children think it's their responsibility to move where you are? Are you going to move where they are? All of these questions need to be talked about so that everyone's on the same page. You can even go and visit assisted living facilities while you're able and have an idea of, okay, well, these are my top 3. When the time comes, you tell your children, your nieces and nephews, your whoever, your brothers and sisters, these are the ones I'm liking. So if the time comes, make these a priority. You can also think about it from a financial standpoint. Can you afford them? Does it look like you're going to be able to afford them? Of course, having the conversation with your loved ones, that is the takeaway for the day. Our office offers seminars, this last point here, for VA and Medicaid planning. So that is a big piece of the puzzle. If that looks like it's going to be part of your future, VA benefits or Medicaid planning, that's something we do.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we would welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.